Good morning, everybody. I am Romeo Arrieta. I'm your Marin Realtors CEO, and I'd like to thank everybody for joining us here today. This January, I celebrated 3 years with the association, and I'd like to thank the membership and our association leadership for the opportunity to serve this amazing organization. We've had a couple of challenges over the last few years, and I'm happy to say that we've met and addressed the challenges very, very well. And I'm happy to celebrate this year our 102nd year as an organization. We have a great program today, and it's our annual meeting of the corporation. So we have to do a little bit of work before we get to the rest of the program. So I'd like to introduce our Marin Realtors president for 2022, Logan Link, and she'll lead us through the business portion of the day. I've already said a little housekeeping, but I've noticed that a couple of people joined, so I'm going to repeat it. Everybody except the speakers will be muted by default. We'd love to see everyone's face, so please share your videos. And finally, put any questions that you have in the chat, and the presenter will answer them as best as they can in the order they are received. Hopefully, they'll address them verbally during the presentation. I'm going to turn it over to Homa Razuli here and introduce our sponsor. And let's see, Homa, you should be unmuted. Let's take it away.
Okay. Well, good morning, everyone. It is so good to see you. Hopefully next time we be face to face, but it is nice to see everyone. I'm Homa Razuli. I'm a reverse mortgage specialist with Mutual of Omaha Mortgage. And I just wanted to say really thank you for all your support and all your relationship and all your trust and taking care of your senior clients. Reverse mortgages have gone up about 40% in the last 2 years. It has been really a great financial tool to help our senior clients for FHA product over 62 years old, for jumbo product over 55 years old. And I have been receiving a lot of different solutions for clients that are bringing up different ideas. One of them is one of my clients is pulling equity from her house to help her daughter to buy a house. I have another client who is pulling equity from their house to buy a vacation home or investment home. So there is a lot of different opportunities that we can help our clients. And I depend on you because you are always there to help your clients. Everything is going up. The inflation is high. The rates are going up, but we still have a very good rate regarding our FHA products. And I'm always here to run analysis for your clients. Don't hesitate to call me for any questions. I love what I'm doing. I'm very passionate about it. And I've been again marked as in a president club for 2021 as well. And it's been like 13 years that I've been in president club, and it's all because of our relationship together and helping our senior clients. And I'm always there to help. So please don't hesitate to call me with any question. We will send you a nice whiteboard video because it was a long one and we didn't want to take your time, but Francesca is kind enough to send that. Please take a look at it, and if you have any question, let me know. We appreciate that, and please take care and see you guys all soon. Thank you.
Thank you, Homa. Always so great to see you. So hi, everyone. Good morning. Thank you so much for joining us today. So I'm Logan Link. I'm your 2022 president, and I hereby call this annual meeting of the corporation to order. So first, I would like to just recognize our current board of directors. We'll have everyone's faces up on the screen if Craig, if you want to pop them up there. All right, so this is our 2022 board, which I have to say is such a dynamic group. We've really been kicking things off well this year. So many thanks to everyone. All right, that's our board. Okay, so I would just say in general, I think we're kind of all feeling like we're at the beginning of a new era, which is really exciting, right? Like, at least personally to me, and I think within the association and at our board meetings, we're all kind of feeling this energy of hopefully COVID is a little bit behind us and we can start being together again and just thinking about things in new ways. And that's really exciting. And then on top of all of that, it's the spring season, it's beautiful out, things are getting busy, there's so much demand out there. I mean, I think we all know that there's definitely like a feeling in the air right now. So kind of where our minds are as an association is very much in keeping with what our theme is for the year, which is everything is about you. Everything is about members. And I think we as agents, especially as spring comes up, we all have to be here for our clients all the time. And so what Marin Realtors wants to do is we want to be here for you. So there's kind of a few highlights that I'll just briefly mention of things that we're working on and focusing on right now. And I'll keep it quick because I know we're all excited to hear from Gov today. But kind of the first thing is like education and speaker series and business type meetings. So we have a few really interesting things coming up that we'll announce at the end. But what we've decided to do is we'll keep these things on Zoom, even as COVID starts to go away. And that's really out of respect for the fact that we recognize that you as agents are busy. And there's something really, really nice about being able to skip the commute or being able to multitask or put in your AirPods and take a walk while gathering valuable information. So that's one thing that we are planning to continue on with. And then secondly, I think we're still all feeling like we do want to get back together in person though, and see each other, but maybe this time in like a little bit more of a casual way where we can actually just chat with each other and connect and be out in the community. So I've been working with staff on a couple of events. So keep an eye out in like late March, we'll probably announce something, just a chance for all of us to get outside, get together like old times and just hang out for a while. And then actually this morning we heard from Women's Council of Realtors, and they have something coming up that I think will be really fun. It's a little like St. Patrick's Day mixer on March 17th from 4 to 7 p.m. at the Holmes Burrell outdoor patio, which should be really cool. So if you're interested in going to that, just shoot me an email and we'll connect you with the right person. But that'll be a fun, like, let's get back together kind of starting point there. And then the third thing is our association is very focused on being a source of information for everyone. So something that we're working on right now is a total website overhaul, which is a little bit of a longer process. It's a project that we've all been working really hard on, but we're excited about it because this association is such a wealth of information. And what we're hoping to do is just get all of this information into one easy place where everyone knows if I need to know, what do I have to do in terms of sewer inspections in Las Colinas. Look at the Marin Realtors website and the information will be right there. So that's kind of a longer term thing that we have in the works that I think will be really cool. So that is kind of the highlights of what's going on here. And I know I always do this, but I'll pop my contact info into the chat. And I would say, really do like reach out if there's anything that's just on your mind. Like it's actually super helpful to hear directly like what you're thinking about, what questions you have, or when you're out in the field, like what topics are bouncing around in your head that you'd like to learn more about, or even if there's someone who you think would be good for our speaker series, like let me know. We love that kind of thing. So my email address will be in there, and it's your association. So we want to customize it for you, and it'll be a good spring season. All right. So one more little piece of business before we get to Gov. We will hear from Romeo for a financial update on the association. Romeo, you're muted.
Thank you. And 2 years into this, I'm still learning how to unmute myself, but good news is I just figured that one out. So I'm actually going to be giving a report for our treasurer on behalf of our treasurer, Beth Cezanne, who couldn't be here today. but I have a brief report on our finances and membership. At the end of 2021, Marin Realtors had 1,381 members, and that is a 5% increase from the year before. And fortunately, that has put us in a very positive and stable financial position to be able to continue bringing the great services to Marin Realtors. As always, copies of our financial reports are available for viewing. You can contact us. You can swing by the offices in San Rafael. And that concludes the Treasurer's Report. And let's get it back to Logan.
Perfect. Thank you. All right. Thank you, Romeo, for that. Appreciate the update. And that there concludes our annual meeting of the corporation. So that portion is now adjourned and we can get on to hear about Gov. So I think most of us at this point know Gov Hutchinson. He's the Assistant General Counsel of the California Association of Realtors. Incredibly impressive. His resume is unreal. But I think truly when he speaks, that he kind of speaks for himself, right? I think that if you don't know Gov already, by the time we're done with today, you'll understand why we all love him and why we all look forward to this annual update. So ladies and gentlemen, please join me in welcoming Gov Hutchinson.
All right, good morning, everybody. Good to see you virtually one more time. I think maybe we will be live next time we do this. I'm pretty sure we will, actually. My current plan is to start hitting the road probably in May, it looks like. So you never know with this crazy COVID thing, but it looks like that's the direction we're going. It looks like things are looking pretty good. And I think as Logan mentioned, yeah, we're sort of almost past COVID now in the legal world as well. So what I'm going to do today is give you, as I always do, a legal update, which means all the legal stuff I think you need to know. By the way, maybe almost the most important legal stuff you need to know this year is the new purchase contract. And you are going to have a free class on this coming up, I think on the 5th of April. With my colleague Neil Kalin, who's actually the lead attorney advising the forms committee regarding the forms. So that'll be really good. So I encourage, that's probably a really good idea if you join that. It'll be virtual. And to give you, he'll go over all the changes to the purchase contract and sort of the reason for them as well, if you're interested. So I'm going to focus though, I am going to talk about some forms, but I'm going to talk about mainly legal stuff. Let me start with the two things I've been talking about constantly for 2 years, which it looks like I'm probably going to be able to stop talking about pretty soon, if not now, and that's COVID and evictions. I mean, in the COVID world, on the state level, pretty much regulations are over. You are back to where you were pre-COVID. In other words, the last thing was the mask wearing requirement, which is it's now a recommendation rather than a requirement, both in indoor public spaces and in offices. Now, one caveat, of course, is local governments, if they want to, can still impose stricter rules. I'm in Los Angeles County, which up until a couple of days ago still had their own rules, but even LA County has matched the state rules. And I don't really keep up so much on locals. You would know better than I do if San Rafael or Marin has anything, but I don't think so. In other words, you don't have to wear a mask anymore. It's just regardless of your vaccination status in real estate context. I mean, still, like healthcare facilities and in care facilities and public transportation, you still have to wear a mask, but in the things that you deal with, which is open houses and showings in offices, whether you're vaccinated or not, you don't have to wear a mask. Strongly recommended though. On the other hand, of course, keep in mind that the owner of a house or the owner of an office can impose their own rules. I mean, someone in a house can say, we're gonna have an open house, everyone needs to wear a mask. That's my rule. An office or a company can of course do the same thing. So always keep that in the back of your mind. So you never know what you're going to come across in that context. But the state prohibition, the state requirement to wear masks is over. I'm pretty sure the local ones are too, both in indoor public spaces and in offices. So we got that out of the way. What about evictions? Well, here's the interesting thing about evictions. You remember that the eviction moratorium ended last September, but it did have a couple things still remaining. And there really is one sort of rule still remaining in effect until the end of this month, 3 weeks, and that is the requirement that you have to, before you try to evict someone for non-payment of rent, you have to still make an application for rental assistance, okay? So in other words, you can evict someone, but you have to go through the efforts of going to housingiskey.com and making your application, and an email goes to the tenant, and the tenant has 20 days to cooperate. If the tenant doesn't cooperate in 20 days, you can go ahead with the eviction. Well, today is the 8th, right? 20 days from today is March 28th. So theoretically, you could be delayed until then. What if the tenant does cooperate? Well, then you can't go forward with your unlawful detainer until you find out if the local government entity that you applied for rental assistance is going to say yes or no. But that ends on March 31st. So in other words, if you have an application in for rental assistance and you're still waiting for a response from the city or the county as to whether you as the landlord are going to get that money, then as of March 31st, you don't have to wait anymore. You can proceed with the eviction. Now, what can happen on April the 1st, when this last remnant of the eviction moratorium is over, is local counties and cities, if they want to, can reimpose their own eviction restrictions. Guess what? LA, where I live, is doing exactly that. In Los Angeles County, where I live, effective April 1st, they're going to go back to pre-September. They're going to go back to, you can't evict someone for non-payment of rent if they have a COVID hardship. That's not true anywhere in California right now, but because of state law. But the state law expires on March 31st, which gives local governments the right at that time, if they want to reimpose any type of eviction restrictions. LA is doing that. You would know better than me if San Rafael or Marin was contemplating or has actually already decided to do any local eviction moratorium. But on the state level, it's going to be over, and there's no movement to extend it beyond April 1st. So basically, evictions are back subject to local restrictions. Evictions will be back to pre-COVID in about 3 weeks. Okay? So those are the two big things I've been talking about forever. Now I get to talk about other stuff. And if you're going to excuse me for 1 second, I got to close my window. I'm not sure you can hear that or not, but I just want to make sure. Anyway, so let's talk about new laws. The governor signed 836 new laws this year. I'm going to tell you about all of them. Just kidding. I'm going to tell you about maybe about 10 of them, okay? How many of those 836, by the way, affected real estate in your life? I think we came up with a number of 31. If you want a handout on our website, we have one called 2022 New Laws Affecting Realtors, summarizes everything. Maybe there's only about 10 of them that really affect you, and those are the ones I'm going to talk about right now, okay? Before I address any other issues. New laws that affect realtors. Let's talk about the ones that affect you directly. A couple of new disclosure requirements. One of them deals with mold if you are a landlord or a property manager, you need to know this. That is, if anyone gets a new residential tenant this year, starting January 1st, you have to give them a mold information booklet. And it's not called the mold booklet, it's called Information on Dampness and Mold for California Renters. Where do I get this booklet? You can get it for free on zip forms in the library called Electronic Publications, EPUBs. All you have to do is email it to your tenant. You don't have to give them a hard copy, and you've satisfied. It's only for new tenants. Tenants that carried over from last year don't have to do it. By the way, you may be wondering, why is this requirement to do a mold booklet? Why this year? Why not last year, next year? What's so special about mold right now? And the answer is nothing. Let me take you back in history. Do any of you remember 2001, if you were in real estate back then? If you might remember back then, that was the year everyone was sort of getting hysterical about mold. I remember it vividly. Everyone talked about mold. Everyone was having speakers on mold. Everyone's having experts on mold. Everyone's having mold inspections, blah, blah, blah. I know people still do mold inspections, but it was crazy that one year. And as part of what was going on that year, there was a law passed that required the California Department of Public Health to do two things. Number one, come up with a mold booklet that would be given to tenants. Well, it only took them 21 years to come up with the booklet that they were tasked to come up with in 2001. So it just came out. So please give it to your tenants. What was the other thing that the California Department of Public Health was tasked to do 21 years ago regarding mold? Answer: to do some type of scientific investigation and come up with some guidelines to say, this amount of mold in the atmosphere is unsafe. This amount of mold spores is okay. In other words, a cutoff. Well, we're still waiting. That hasn't happened yet. 21 years later, we don't have an answer yet. I don't think most of us really think about it too much. I think your normal reaction is, I don't want any mold at all. If there's mold, I want to get rid of it. But there really isn't much of a, I don't hear people talking about, oh, I got X number of mold spores. I just did a test to see how many mold spores there are in the area. But the point is, there are still no California scientific guidelines or standards as to what level of mold spores in the air is an unsafe level. Okay, so nothing has changed on that level. All right. A second law that requires a new disclosure for you is going to take effect July 1st. Right now, you got a lot of disclosures you got to do, right? And they're all listed in paragraph 11 of the purchase contract. There are what I call 5 big disclosures, which are disclosures that give the buyer a 5-day right to rescind. I mean, as you know, buyers typically have 2 ways to get out of a contract. Number one, they have contingencies, and number two, they have a statutory right to cancel. I know in your market, a lot of people are probably making non-contingent offers, which means they can't use that to get out of a deal, but then they still have the statutory right of rescission. But of course, I think a lot of you are also eliminating the buyer's statutory right of rescission by giving them the disclosures, making the disclosures available to them before they sign their offer. And if you do that, the buyer doesn't even have the statutory 5-day right to cancel. What are the big disclosures that trigger this 5-day buyer right to cancel if you don't give it to them before they write the offer? Well, remember, for years and years, there were just 4 of them: the NHD, the TDS, the seller property questionnaire, and the lead paint form. Last year, there was a 5th big disclosure added: the fire hardening defensible space form, only required if it's in a very high or high fire zone. Well, this year there's going to be a 6th big disclosure effective July 1st called the appraisal discrimination notice. Now, and that's not the exact name of the form, but anyway, it's going to be along the lines of that. So this is a form that's you're going to give to your buyers, and it's going to give them a 5-day right of rescission. But guess what? this form, unlike the other 5 disclosures, is actually going to be pre-attached to the purchase contract. So by the buyers submitting the purchase contract, they will be acknowledging that they've already received this form, the appraisal discrimination notice, so they won't have a right of rescission. Because by definition, since it's attached to the contract that they're offering, there's no 5-day right of rescission. What is this form actually going to do? It's basically just saying to the buyer, hey, buyer, and it's actually a disclosure to the seller also. Unlike all of the other disclosures I mentioned, this is a disclosure that must be given to the buyer and the seller, which is why it's attached to the purchase contract. And this form is basically just telling your buyer and seller, if you think you got an appraisal that was artificially low because of discrimination, in other words, the appraisal was low based on who you are as opposed to characteristics of the property, the form is simply going to say, you know, you're entitled to an appraisal with this not discriminatory, and here's where to file a complaint if you think it was discriminatory. That's all the form is going to do. Pre-attached to the purchase contract, you're good. What if you use something other than the RPA for your purchases? Well, you have to check with whoever provides those forms to see if they also are going to have this, some type of this mandatory appraisal eviction notice. We will have this form also available on zip form in July, but you're probably not going to need to access it that way since it's going to be attached to your purchase contract. Okay, so that's a new disclosure form, but you're not even going to have to think about it. It's just, you don't have to fill it out. It's just pure information, and it's pre-attached to your contract. It goes to your buyer and your seller. Okay, what else is going on affecting realtors directly? There's a third law that requires some type of form, and that is, listen to this carefully. There's been a lot of emphasis, as you know, on fair housing recently, which is good. And here's a new law, another July 1st new law. You know what a deed restriction or restrictive covenant is? Of course. I mean, deeds, sometimes if you pull up a deed, a recorded deed against your property, you'll notice that there's some attached to it, some restriction. Like there are affordable housing deed restrictions. This property can only be sold to someone with an income of this amount. You'll come across deed restrictions. This property can never be used to sell alcoholic beverages, things like that. And most of them are usually legal, but then you'll occasionally come across a deed restriction that says something bad like, this property can only be sold to Caucasians or something like that. And you'll sometimes also see these in the CC&Rs. A restrictive covenant in the CC&Rs that says, you know, no Jewish people can buy this house or something like that. Those used to be in the bad old days legal, but I'm sure you're aware these are not enforceable at all now. So what's the problem? The problem is some people buy a house and they realize that there is this deed restriction or something in the CC&Rs, and they're just offended by it. They say, I want that removed from the public record. I don't want that attached to my property in any way. I want that gone. Well, there's now a procedure to do that. There's a new law that requires, that says you can go to the county recorder's office and they'll have a form for you to fill out and say, I want this unlawful deed restriction redacted and removed from the property within 3 months. And they have to do it for free within 3 months. Within 3 months, they have to determine if it is in fact an unlawful deed restriction, and it probably is, and then they have to remove it within 3 months. How does any of this affect realtors? Well, you, interestingly enough, have a disclosure obligation. The disclosure obligation is if you happen to be listing or selling a residential property that does happen to have one of these deed restrictions, if you are aware of it, you have to disclose to the buyer that there's now a streamlined procedure at the county recorder's office to get it removed. The key thing is you have to do this if you're aware of it. And first of all, how's anyone going to prove that you are aware of it? I have no idea. And second, I don't think most realtors would normally be aware of it. because you don't have an obligation to look at the deed, and you don't have an obligation to read the CC&Rs. But maybe perhaps you will be, in the course of your transaction, aware of this. You might be aware of this either CC&R or deed restriction that's looks like it's possibly unlawful because it's, you know, one of the ones I described, it's like racist in some manner. If that's you, if you happen to be listing or selling the property and you happen to be aware of this restriction, you have an obligation to tell your clients. Do we have a form for this? Well, it's not actually a form. We have something on not Zip form, on the CAR website called sample legal letters. These are so you're in a transaction, you don't have to call a lawyer. Like it's like a demand letter. I demand that you pay me the rent. I demand that you this or that, you know, or demand that you take some action in the course of a transaction or something like that. Well, we've got a new sample letter, which is basically, it's a disclosure to client regarding possible unlawful deed restriction or restrictive covenant. So if for some strange reason you happen to be in the situation where you're in a transaction, residential, and you happen to be aware of this possibly unlawful deed restriction or restrictive covenant, you can just email your client, but you might as well just use the letter that we've prepared for you that says it in the right way. You're just basically telling them, I've noticed that you have a potentially unlawful deed restriction or restrictive covenant. Did you know there's a streamlined process to get it removed at the county recorder's office? Boom. So you may never use this letter your whole life, but you might. So that's a new disclosure requirement that is satisfied by this sample letter effective July 1st. Okay. All right. Other laws affecting realtors directly. Got some good news for some people who changed their names. When you market yourself for sale signs, everything else, you know you have to use your DRE number and you have to use your name. You got to use your last name as it appears on your real estate license. First name, you can use a nickname. You can shorten your name. It doesn't really matter what you use as your first name, as long as you have your last name as it appears on your real estate license. But what if you, in the past, you know, you were single or whatever, or married, and then you had your license in that name, and then you got married or divorced, or for whatever reason, you changed your last name, and you also changed your last name on your real estate license. Well, the good news now is you can now in your marketing use either the old last name or the new last name, either one or both. In other words, you don't have to, you can use in your marketing any last name that you ever had your real estate license in. Maybe you got married or divorced 3 or 4 or 5 times. You may have a lot of old real estate licenses. You can use all of those names. You can have some signs with marriage number 2 name. I'm just sort of kidding here, but you can do it. But the point is, if you had a license with that last name, you can use it in your marketing. Okay. All right. Other laws affecting realtors directly, starting not 2022, but 2023, getting back to fair housing. If you are going to renew your real estate license, you'll find that you're going to have to take an extra hour of continuing education to renew your license. It's going to be related to what's called implicit bias. The idea is that all of us without even knowing it unconsciously are biased in some ways. There's going to be some training on how to recognize and address any implicit biases you have. It's also going to be more training on fair housing. So it's going to be an extra hour of required CE you're going to have to take to renew your license, not this year, but if you renew your license starting 2023. And I'm sure CAR will offer it for free, so you'll be able to do it. Okay. All right. Other laws affecting realtors directly. There's been some clarification of Proposition 19. Remember back in April, Prop 19 passed or took effect, And Prop 19 sort of expanded the ability of certain people to buy and sell residential real estate without getting their property taxes going up, right? I mean, what's the normal rule, of course, is your property tax basis in residential is based on the purchase price for the property. Once you bought it, thanks for Prop 13, it doesn't go up very much every year. It can only go up a very minimal amount. But then you sell that house and buy a new one, of course, the property tax on your new house could go way up because it costs a lot more. For years, we've had something called Prop 60 or Prop 90, which says if you're over 55 or disabled, you could one time sell your existing house and buy a new one for lesser value in the same county and transfer your property tax basis from the old one to the new one. Well, Prop 19 expanded that to say if you're over 55 or severely disabled or the victim of a wildfire, you can do this not just once, but 3 times. You can sell your house and move anywhere else in California and still do it. And you can do it even if the new house costs more than the old house. So it greatly expanded this. When the proposition took effect, though, there were some open questions that needed to be resolved. They have since been resolved. So what is the answer? First of all, if you remember, you have a 2-year window. I can sell my house and I have 2 years to buy a new one, or I can buy a new one. I got 2 years to sell the old one. First, it was clarified that if you did either one of those prior to April 1st, you can still do the second one after April 1st and take advantage. Second, you don't have to be 55 when you do the first leg, as long as you're 55 when you do the second leg. Married couple, only one has to be 55. And very importantly, there's an inflation factor. Let's use some numbers. Let's say you bought a house long time ago, 40 years ago, for $200,000. So you're paying property tax based on $200,000 as it's been slightly adjusted over the years. It's now worth $1 million. So I have my $200,000 house worth $1 million. I want to sell it for $1 million. If I sell first, I have 2 years to buy the new one. If I buy a new one for $1 million or less, no increase in property tax. But now it's even better than that. If you buy the new one during the first year after the sale of the original, it can cost 5% more with no increase in property tax. So bought it for $200,000, it's worth $1 million, sell it within the first year for $1 million, and then buy within a year a replacement for up to $1.05 million, no increase in property tax. If I wait a year before I buy the replacement, it can cost up to 10% more than the sale price of the original. So originally bought it for $200,000, selling it for $1 million, buy a new one for up to $1.1 million in that second year, no increase in property tax. Well, what if I sell my original for $1 million and I buy a replacement for $1.2 million? It's more than 10% above the sale price of the old one. Can I still transfer my property taxes? Yes, with a slight adjustment. So you bought it for $200,000. Property tax basis is still based on that low number, now worth $1 million, sell it for $1 million, buy another one, $1.2 million. What's my property tax basis going to be on the $1.2 million house? It's going to be the original low $200,000 plus the difference between the purchase price of the replacement and the sale price of the original, which is, in my scenario, $1.2 million minus $1,200,000. So my property tax basis on my new $1.2 million house would be like $400,000 rather than $1.2 million. The whole idea here, of course, is to remove a barrier that would prevent certain people from wanting to sell. The barrier being, I don't want my property taxes to go up so much. Well, if you're over 55, severely disabled, or the victim of a wildfire, they might not go up at all, or they might not go up that much. So that's the whole thing about Prop 19. By the way, what if a married couple owns a house together and they split up and they want to sell the family home and each one wants to buy a replacement property and they're over 55. Can each one of them transfer the property tax basis from the original to the replacement? Do they each get half of that benefit? How does that work? And the answer is only one of them gets it. So one of them gets the benefit and the other one doesn't. Well, which one gets it? Well, they're going to have a fight to the death. They're going to work it out. They're going to negotiate it. I mean, a court would step in if they couldn't come to a resolution, but one of them, I'm sure the other one would get some compensation for this, but one of them, it's usually part of the divorce settlement, where one of them gets the right to transfer the property tax basis and the other one doesn't. That's factored in. Okay. All right. So that's it on Prop 19 update. There's some law clarifying that. By the way, I'm going to take a look before I go any further at the chat. See if there's any question. I'm going to get all the questions at some point, of course, but yes, Romeo's talking about the class.
I've actually got a couple of questions that have come to me anonymously.
Oh boy.
Through other channels.
Okay.
And by other channels, I mean somebody texted me.
Right, I got it.
Because I didn't see many come through the chat otherwise, but okay, there seems to be a lot of confusion from broker to brokerage about non-contingent offers and right of rescission. So the question is, if a buyer gives a contingency removal, removing all contingencies without having received a statutory disclosure, does that mean their rescission rights are still intact?
And that's exactly right. Yes. So in other words, the two things have nothing to do with each other. I mean, the purchase contract gives the buyer X number of days. There are 8 contingencies in the purchase contract. One of them is called seller documents. The disclosures are considered to be seller documents. So if you didn't make any changes to the purchase contract, the buyer would actually have 17 days after acceptance to review the disclosures. But let's say you make a non-contingent offer. So they have 0 days to review the disclosures. Completely separate from that, they have these 5 disclosure forms that give them 5 days to just walk away. 5 days from when? 5 days from the day the buyer's agent receives these disclosures. Somebody say, I thought it was 3 days. So it's 3 days if if hard copies are hand delivered, 5 days if they're emailed. I'm assuming they're going to be emailed. That's why I say 5 days. But as I said, and that's in normal. But the seller can eliminate that 5-day right of rescission. But the way to eliminate those is you have to make all those 5 disclosures available to the buyer before they produce the offer. And you have to prove that the buyer sort of acknowledged that they did receive the disclosures or a link to the disclosures. But the point is you get something from the buyer saying they have received the disclosures. If you do that, if you get that from the buyer at the time, at or before the time they write the offer, acknowledgement, yeah, I've got them, or they've signed a link or acknowledge a link to the disclosures, then they don't have a 5-day right of rescission. By the way, completely separate from this is, remember, the purchase contract says contractually buyers have an obligation to sign and return the actual disclosures. And I keep talking about the same ones: NHD, TDS, lead paint, seller property questionnaire, and the fire hardening defensible space. And the buyer has a 17-day deadline to return those disclosures. If the buyer doesn't return them, seller can cancel. Even though the buyer received them early, had no right of rescission, no contingency, buyer still has an obligation to sign and return them contractually. If they don't, it's another way seller can cancel the buyer. Okay. But yeah, I hope that clears up a little bit, because that's a very, very, very common question that comes up, the whole concept of disclosures versus contingencies. I'll give you another scenario. You give all the disclosures to the buyer before they write the offer, so they don't have a right of rescission. Then halfway through escrow, the seller or the listing agent realizes, oh, I forgot to tell you something. There's a material fact I'm aware of that I didn't put on the TDS or the SPQ or whatever. Well, of course, that in the middle of escrow, you now have to give the buyer's agent this written disclosure. And whatever form, whether you give it to them on a blank piece of paper, on a TDS, on an whatever format you give it to the buyer, it's considered to be an update to the TDS, and it gives the buyer a new 5-day right of rescission. So you try to make sure you do all your disclosures and you don't forget anything. Or if the listing agent discovers something during escrow that they weren't aware of before, it's not that they forgot about it, they just weren't aware of it. Now they are aware of it, you got to give a new disclosure. By the way, though, this does not apply to the buyer's agent. So if the buyer's agent discovers during escrow an issue, a problem, a neighborhood issue, whatever, of course you got to tell the buyer, but the buyer, that does not give the buyer any right to cancel. The reasoning of the law is buyers don't remove your contingencies until you're satisfied you've educated yourself about everything you need to know about the property, and you have a buyer's agent to help you do that. Otherwise, buyer's agents could deliberately wait and hold things back, knowing that if they produced it during escrow, they would give their client a right to cancel, right? And that's obviously, that'd be very counterproductive. So this comes up, I'm spending a little time on this, nothing new here, it just comes up time and time again. I hope that clarifies it. Romeo, you said there's another question, or?
Yes. It is, question under new language in the RPA. What if you remove your contingency without having complete HOA docs, and they then come during the escrow? Do they give the buyer a right to cancel when they come? And what about a city resale report?
Yeah, very good questions. And the answer is no. They do not give the buyer any right to cancel. I mean, the contract is very clear. As written, the contract, the buyer has contingencies, and they don't have to remove those contingencies until they receive the HOA docs or receive the city transfer thing. But if the buyer makes the decision, I am removing those contingencies, if they decide to remove them, even though they haven't received the information, that's their risk. The buyer is taking the risk. And the fact that they removed it, then the HOA docs come in, and there's something really significant on the HOA docs, buyer, you shouldn't have removed your contingency until you receive them. I mean, it's a very risky thing, removing contingencies. I mean, ideally, the seller has given you the HOA docs and the city transfer report. They've given you all that stuff pre-writing up the offer, so you've had a chance to look at it before you wrote the offer. But if that didn't happen and you remove your contingencies anyway, then there's no cancellation right that the buyer has. Okay. All right. Related issue. There's another new law. Speaking of inspections, let's say you hire a home inspector to do an inspection. By the way, another thing to remember is just because you've removed your contingencies, including your investigation contingency, doesn't mean you still don't have the right to do inspections. You have a separate right in the purchase contract. You have 17 days to do buyer investigations. Now, of course, the seller could counter that out too. The seller could say, not only do you not have a contingency, you don't have the right to access the property either. But the seller would have to specifically counter that. If the seller doesn't specifically counter that, the buyer can still do an inspection. They can find out what's wrong with the property that may cause them to decide not to buy the property. However, since they don't have a contingency, they're going to lose their deposit, but they still can't be forced to buy the property, right? So you do have the right to inspect. Speaking of inspections, you hire a home inspector, does an inspection. Inspector finds problems. Did you know you cannot hire that inspector to do the repair work for the problems that inspector identified in the inspection for 12 months? You can't hire the same person. I'm not talking about termite, for example. The same person who does the termite inspection can do the termite work. I'm just talking about home inspector, the actual home inspector you hired. There's now another exception, that is sewer lateral. So if the home inspector, as part of the home inspection, inspects the sewer lateral connection in the pipes, and by the way, you need a contractor's license to be able to do that type of inspection. Anyway, so the home inspector, through that home inspection, determines, yeah, there is sewer lateral work I recommend being done. You can hire that person to do it. So that person, you don't have to wait 12 months. That inspector can do the sewer lateral work. Okay, the sewer lateral work that was called out in the inspection, just like a termite inspector can do the termite work called out in their own inspection. Okay, all right. So that's a slight change. Other things that have changed. By the way, I'm saving the best for last, not the best for last, the most significant change to the end, and that's SB 9, of course. Couple more things to mention is they've tightened up, the government has tightened up the rules in California regarding emotional support animals. You know, there's a distinction, you probably know this, between service animals and emotional support animals. A service animal is a dog that has been trained to perform a service for a disabled person. If it's a legitimate service dog, that dog can go anywhere. Restaurant, transportation, there's nowhere that dog's not allowed to go. But then we have something called an emotional support animal. Number one, it doesn't have to be a dog. Number two, it's not trained to perform a function. It's just providing, by its existence, is supplying emotional support. Did you know emotional support animals don't have the same rights as service animals? A restaurant can turn away an emotional support animal. A museum can turn them away. A plane or a train can turn away an emotional support animal. Okay. Real estate, though, they're treated the same. In other words, if you're a landlord or an HOA and someone has, whether it's a service dog or an emotional support animal, you have to allow them either way. When it comes to an emotional support animal, though, the landlord or the HOA is entitled to written evidence from a caregiver saying, this person, I've examined this person, and I've determined they have a disability and they need an emotional support animal. Prior to this year, you could have just gone on the internet to get that. And someone could just sort of examine you on the internet and say, oh yeah, I agree, you need an emotional support animal, here you go, here's the paperwork. Now, to get the certificate, in other words, the landlord can say, please, in writing, show me from the caregiver the written statement that, based on an in-person examination and a relationship that you've had with this person for at least 30 days, you're making the judgment that this person has a disability and needs an emotional support animal. Okay, so it can't just be just someone off the internet, someone who they actually have a relationship with for at least 30 days, and they've done a clinical examination. It doesn't have to be an MD, by the way. It could just be any type of caregiver who makes this assertion, but that is considered legitimate. So it's a little bit harder to get an emotional support animal. I think we all agree that if someone needs an emotional support animal, they should have an emotional support animal. I don't know if you've ever experienced, I've certainly experienced situations though where people pretty clearly don't need an emotional support animal, they just have a pet and they want to go around a no pet rule. So they go through some way to do that when it's probably not necessarily legitimate. Okay, and landlords and HOAs do have the right to have a no pet policy, right? See, I see a couple of questions already on that. Yes, you can have a potbelly pig support animal. That could be good. By the way, once you get this documentation, does the landlord have to accept any animal? No. You have to accept, you can be reasonable. So if they show up with an emotional support gorilla, you could say, sorry, no, that's not reasonable. Can you refuse certain breeds of dog? depends. Maybe it's a 600 square foot apartment and they show up with a 200-pound dog. You could probably say, that's really not, it's too big for this unit. That's just, it's going to cause problems. You know what I mean? Can you ban all pit bulls? No. You can't ban a particular breed. However, what if you can't get insurance? What if the insurance coverage for the building prohibits certain breeds? That would be a reasonable basis, although the courts are going to say, did you shop around for other insurance companies to see if any of them would, at a not exorbitant price, insure a pit bull or something like that? Okay. Pam asked a question, if HOA allows only one dog and the potential buyer already has a dog and an emotional support animal, does the HOA have to allow both? Yeah, because the emotional support animal is not a pet. It's not a regular dog. It doesn't count, right? Can you charge a pet deposit? Landlords can charge a pet deposit, but they can't charge a deposit for an emotional support animal because it's not a pet. However, of course, let's say the emotional support animal causes damage. Of course, the tenant's responsible. Let's say the emotional support animal attacks and bites one of the neighbors. The landlord would have the right to say, you need to get a different emotional support animal. You don't necessarily have the right to that emotional support animal. In fact, if the landlord doesn't require that tenant to get a new animal, that landlord's setting themselves up for liability, because have you ever heard me talk about the one free bite rule? If you're a landlord and you have a tenant with a dog and the dog bites someone, you, the landlord, can't be sued. You didn't know that your tenant had a vicious dog. Vicious is a legal term, defined as, an animal that's bit. But once you're aware that you have a tenant with a dog who has bitten someone, and then that dog bites someone else, you are on notice that you had an animal. You had a duty to protect the other tenants from this animal. So you actually almost have a requirement to make the tenant actually get rid of that dog. Okay. Rocky had a question. The old RPA specifically said conduct inspections and investigations. Yeah, I don't know. I think, Rocky, the thinking is the word investigation includes inspections. It doesn't have to say the word, because it does say pretty clearly in paragraph 12 that the buyer has an absolute right to do inspections of any kind. And it does mention one of the examples of the inspection you can do is a home inspection. So it does sort of bring it back. But that of course can be countered. Seller can counter paragraph 12 and say, no, buyer, you can't even do an inspection. That's, in other words, you don't have a statutory right to inspect. It's a contractual. Charlene, do landlords have to allow breeder or stud dogs for guide dogs for the blind? Yeah, usually those are considered service animals. There are other special rules too, like an animal trainer. You have to allow them to have an animal. Maybe they're training guide dog, they're training service animals. They're not certified service animals yet, but they're in training to do that. You would have to allow them. There are some details. Okay, let me keep going. I'm almost done. Two more laws I want to mention. Like I said, I saved the best for last, or the worst for last, however you want to look at it. The fire hardening defensible space. And I've talked about it up here before in Marin. See, I'm saying up here, even though I'm in Los Angeles. I've talked about it to you guys. And that is, remember the law says, if your listing is in a very high or high fire zone, the form is required. If it's not, the form isn't. By the way, I've come across so many times where a lot of realtors or their clients are providing the fire hardening defensible space form, even though the property is not in a high or very high fire zone, just because they think it's a good form, good information. I'm not saying that's a bad idea, but I think you need to be, and there's a checkbox right on the form where you're basically telling the buyer, this property is not in a high or very high fire zone, but I'm giving you the form anyway. I think what really needs to be explained to the buyer and the seller in this circumstance is, if you're providing the form not because it's required, but because you want to, the seller doesn't have to check the boxes in paragraph 3 and doesn't have to fill out paragraph 4. So you want to explain to the buyer, since this form is not required, the seller didn't have to tell you whether they have a wood roof or whether they have single pane or dual pane windows. So don't assume by the fact that the seller didn't check those boxes that they don't have a wood roof. You see what I'm saying? And then paragraph 4 of that form, where you do have to disclose if the seller has had a defensible space inspection within the last 6 months, that duty to disclose that only kicks in if the property is in a very high fire zone. Similarly, the fact that it says in paragraph 4 of the B1 of that form that the buyer has an obligation within a year after close to go out and get documentation that the property is in, that the property satisfies the 100-foot California defensible space law, that obligation on the buyer only applies if the property's in a high or very high fire zone. So I'm just saying, it does seem to cause some confusion if you provide that form as information, even though you're not required to, because the legal ramifications that follow from it don't apply. So I'm just you need to, if you're going to do that, you need to explain that to your clients. Okay, that's what I'm saying. Anyway, did you know that, and by the way, I remember that Marin County, I'm almost thinking I remember this, that Marin County was one of the places where there were local fire districts trying to tell you that you can't sell a house in Marin County unless you do a defensible space inspection. And unless any of these local communities have passed actual city ordinances saying that, remember, that's not true. CAL FIRE has finally agreed with us that it's not true. And pretty much most of the local companies have agreed with us, unless you have a specific ordinance that says in black and white, you cannot sell a house in this area without first doing a defensible space inspection. Unless there's a law like that, there is no requirement that you do a defensible space inspection before you can close. As far as I know, the city of Truckee is really the only place I've for sure figured out that, yeah, they do require a defensible space inspection as a point of sale mandate. Any event, here's what I'm building up to. There's a change coming. Right now, did you know you are either in a state responsibility area or a local responsibility area? I'm talking about fire, local, state fire responsibility or local. If you're in a state fire responsibility area, CAL FIRE has jurisdiction. And you're in that area has been mapped into very high, moderate, or no fire zone. Did you know if you live in a local fire responsibility area, you're either in a very high or you're in nothing? There are no moderate or high fire zones in local fire responsibility areas. So that's why, as a listing agent, you can count on the NHD report to tell you whether you need to do the fire hardening defensible space, because on the NHD report, the standard main page, there's 2 fire zones, and one says very high fire zone, one says wildland areas. If neither box is checked, you're not in a fire zone today. If the very high box is checked, that's telling you whether you're in a state fire area or a local area, you're in a very high fire zone, the form is required. But what if on the NHD report, the very high fire zone box is not checked, but the wildland fire box is checked? What's that telling you? That's telling you you're in a state fire responsibility area and you're either in a moderate or a high fire hazard severity zone. Well, Gov, you just got through telling me I only need this form if I'm in a high as opposed to a moderate. So which one is it? Well, then you have to, so you currently get an NHD, it says wildland fire area. You have to push your NHD provider to tell you, okay, thanks for telling me I'm in a very high fire zone. Is that high or moderate? and they will tell you, they can tell you, you find out, that'll tell you whether you need the FHDS. Here's what's going to happen this year. The local fire responsibility areas are also going to be mapped into very high, high, and moderate. So when these maps are done, you're going to have listings that last year were not requiring this fire hardening form because it was in a local area, but not in a very high, but it's going to be in a local area in a high. Which means we're going to work with the NHD industry to make sure that they come up with a way to tell you, to be able to tell you that, hey, your listing is in a local fire area, but you're in a high fire hazard zone, which means the fire hardening defensible space form is required. We want to work with the NHD industry so that you can rely on the NHD industry to help you determine whether you need to provide the buyer with the fire hardening defensible space form. Okay, that was a mouthful, but there you go. Which leads me to the very last law I want to mention. And before I go any further, let me look at the questions. Sandy, I may have answered it. No pets rule does not allow you to not rent to a dog trainer or someone with emotional. In other words, that can't be the reason you're not renting to them. I mean, you can not rent to someone for other reasons. But if the only reason you're turning someone down, that the only reason you're turning them down can't be the fact that they have the animal. John's telling me Novato apparently does have a mandatory inspection. That would mean, remember, it wouldn't be the fire inspection, it would be the Novato city ordinance saying that. If that's the case, then that's the case. Yeah, you guys have to deal with your local ones.
Gov, I just want to jump in there and say, sometimes the fire department will tell you that you have to, and the fire department is wrong.
That's what I'm saying.
Have you known that to be the case?
I've totally known that to be the case. That's why I'm being very clear here. If the fire district tells you something, it's not true unless there's a city ordinance, not a fire district rule, a city ordinance, which Novato may have one. I don't check. Maybe these other places, Ross Valley, if they have them, they have them. But it's not the fire district making this decision. And maybe they've worked with their local city government to do this. We don't keep track of this. But I just happen to know Truckee has one. But anyway. Steffi Finkelstein, what if the NHD report is different than the local mapping? You can always rely on the NHD company. They stand behind their reports with a lot of insurance. So, I mean, I always rely on them myself. I don't need to look at the maps myself if the NHD company tells me something, okay? All right, that's enough on the fire stuff. We could talk about that, I think. Britt is encouraging people to call him, sounds good. Someone asked me directly, is it legal to have a deposit for a rent back if you're not charging any rent? Answer is yes, definitely. Here's a question that comes up sometime before I get to SB 9. What if the buyer makes a non-contingent offer, but they do promise to put a deposit in, and they sign liquidated damages, but then they cancel the deal before they even put the deposit in? So it was a non-contingent offer. They got all the disclosures. They don't really have the right to cancel, but they're canceling. They're in breach of contract, right? Right. But they never put the deposit in. So does liquid damages take effect if there's no deposit? No. But you know what? In that scenario I just gave you, the seller can sue the buyer for any actual damages. So they can't simply say, you owe me X, you owe me the amount of the deposit that you were supposed to put in there. They couldn't do that. But if they could show as a result of the buyer canceling, maybe the buyer was paying an exorbitant amount and they're going to resell, the next buyer isn't going to pay as much. That's damages. And they can actually sue the buyer for those actual damages. So some buyers think, as long as I don't put the deposit in, there's no way I can ever get sued. And that's not true. And this is coming up a lot right now, to tell you the truth. Okay. Last topic, although I'll stay for more questions, I'm almost done, is SB 9, just real quick. SB 9, on one hand, it's revolutionary. On the other hand, maybe not as revolutionary as you might think. SB 9, normally, right, we have zoning in California. If you have an R1 zoning, single family zoning, that means you can have a single family home. Prior to SB 9, if you wanted to build another home on your single family lot, you had to go to the city, right, ask for a variance. They could require an environmental impact report, or they could just say no. Now, under SB 9, under certain circumstances, you have the absolute right to build a second property on your single family home. Under certain circumstances. What circumstances are we talking about? First of all, got to be urbanized property, which you can determine from the US Census Bureau if you're in an urban area. Cannot be farmland, protected habitat, conservation area, can't be very high fire zone unless steps have been taken, can't be earthquake fault zone unless steps have been taken, can't be 100-year flood zone, and it can't be in a historic or landmark district. Okay, I'm not in any of those things. Do I have an absolute right to build a second home? Well, you're entitled to ministerial approval, meaning if you meet certain requirements, you have to get approved. There's no discretion. But the city or county can come up with design standards, objective design standards. And if you don't meet those, you can't build the second property. And these design standards, like certain types of roofs, certain type of setbacks, and they can actually limit you to 800 square feet. They can say, okay, yeah, you can build it, but it can't be bigger than 800 square feet. They can allow you to build something pretty small. And they can restrict you further than that. So it's not as wide open as some people think that oh, great, I can build another house now on my single family lot. You have to be able to fit through all those criteria and meet the city's objective design standards that they can put in place. I've seen a lot of cities since then being very strict, cities or counties, but I've seen some are sort of encouraging this. Yeah, go ahead and do it. We're not putting restrictions on you. It depends on where you are. Another thing to remember is the HOA can say no. If you're in an HOA can just simply say you can't build a second property regardless of SB 9. If you're on the coast and you're within the jurisdiction of the Coastal Commission has the final say on any development there. But you don't have HOA, you don't have the coast, and you meet all those criteria, yes, you can build a second unit. And you got to meet the building code, of course, health and safety and all of that. What some people don't realize, though, is let's say there's already laws in effect that say I can build an accessory dwelling unit without, I don't need approval for that. Do you know that if I have a single family house and I want to, first of all, if I want to convert my garage into a unit, I can do that. As long as I meet the building code, HOA can't even stop me. And in addition, if I want to build a detached accessory dwelling unit, like some people call it in-law unit, granny flat or something like that. If it's no bigger than 800 square feet, 16 feet high, 4-foot setback, I can do it. As long as I meet the building code, and the HOA can't even stop me. So sometimes, if you really want to build this additional 800 square foot structure, it's easier to go the ADU route, because you don't, either way, it's ministerial approval. But if you go that route, you don't even worry about the HOA. Furthermore, if you use SB 9 to build the second unit, you cannot use it as a short-term rental. Whereas if you build an accessory dwelling unit, you can use it as a short-term rental. So sometimes it's easier to actually build the ADUs, and that has nothing to do with SB 9. That was the case before SB 9. Also, what about the idea of a lot split? Yes, you can actually do a lot split on your single family lot. All the other limitations I just mentioned apply, plus each lot has to be roughly equal in size. Each one has to be at least 40% the size of the original. Plus, the person who's doing the lot split, if they own the property on either side and already did a lot split there, they can't do it here. So someone can only do a lot split sort of once in the neighborhood if they own multiple properties in the neighborhood. And the person wanting to do the lot split has to sign an affidavit promising they will live in one of the units that results after the lot split for at least 3 years. So there are restrictions on lot splits as well. Plus the whole restriction I just said about if you're going to build something, the city or the county can impose objective design standards, which may make it less attractive to do it. Plus, there's always the issue of the lender, right? I mean, let's say I have a single family home, it's not paid off. They have a lien against the whole property. You do a lot split, you want to build other properties, they still have a senior lien. They may, you try to get a construction lien, they may say, we're not going to subordinate to the construction lien, which may make it impossible to get the construction loan. There are all sorts of factors. The point is, my point is, if you look at it and people say, oh, this is the end of single family home zoning. Maybe, but there are a lot of limitations and restrictions that still exist. And in all honesty, there are more restrictions on this than there are on accessory dwelling units under existing law. It's a lot easier to build an accessory dwelling unit. It's a lot harder for the government or the HOA to stop you. It's very hard for them to stop you if you meet certain requirements. Okay. All right.
Gov,
Yes,
I'm going
sir.
to make a suggestion here,
Yes.
just on time. We've gone a little over. My thought is we can turn it over to Logan. We'll close out the meeting. And if you have time, if you want to stay behind once we're officially over and get to some of the follow-up questions, we'll keep the recording running and, you can get to those.
That is a great idea.
Okay, so I'm going to turn it over to Logan to officially close us out, and then we'll have the extra innings bonus round of questions with Gov for anyone that wants to stick around.
All right. Okay. Well, thank you, Gov. I think that was super interesting. A lot of good information. I personally find the Prop 19 piece to be really interesting as well, because I think with the inventory shortage that we see, like really understanding that can kind of help us get our sellers to see that they can actually move and loosen things up. So very valuable. Thank you. We'll probably keep you for hours after the meeting with all of our good questions. All right, but just to close things out, I'd like to thank Huma Rizzoli for being our sponsor and making this meeting possible. Thank you so much, Huma. We really appreciate you and your consistency with your support. And then just to announce our upcoming event. So what we have coming next is a speaker series. This is the first speaker series of the year, and that is on Tuesday, April 5th. And it is with car attorney Neil Caitlin. And Neil will mostly be focusing on the new RPA. So this could be a really great 1 hour crash course, kind of right at the beginning of the spring season, where I'm sure we will all be writing a million offers. So tune in for that. And we will include all of the info in the Realtor Rundown email, which goes out on Mondays. And then the Women's Council of Realtors event, just to remind you again, is on March 17th. So it's St. Patrick's Day event from 4 p.m. to 7 p.m. on the patio at Holmes Burrell in San Rafael. So the link to that will be in the rundown as well. And then we'll also include a recording of this meeting so you can watch it back and soak up all the good information. And if you're not receiving the rundown, which sometimes can happen if you switched brokerages or something like that, just shoot us an email and let us know and we'll put you on the list. It comes out every Monday and it's always chock full of good information. So that's president@marincountyrealtors.com. I think it's .com. And we'll get you on there. All right. So that is that for our meeting. Thank you, everybody, and have a good one. Feel free to hang out after if you'd like to ask more questions to Gov, but otherwise, hopefully see you at the WCR event and then again on the 5th of April. All right.
Thank you.
Bye.
Okay, so now, Gov, I think we're in the extra innings bonus round. So I see there are a couple of questions in the chat, and if you don't have any questions, I can channel some questions that I've received.
Yeah, Romeo, I don't see any that I haven't got to yet. So if you have any questions. Or you can, people can unmute themselves if they want, sure.
It's true. I'll pop in with one.
Please.
Yeah, so thank you. All right, so I was actually writing an offer this morning and kind of came across this question while I was doing so. It's something I've always just sort of like skipped over diving into the details of it. And it's maybe kind of a specific question. So if you don't know, don't worry. But for non-contingent offers, when we're doing the buyer inspection advisory or buyer inspection waiver form, there's a little part on there that says like other inspections recommended by broker. And it's like a fill in the blank kind of thing. Should we be like writing in other inspections that we would recommend? Like, let's say the home inspection, pest inspection, sewer, and roof inspection are all included in the disclosure packet. Is it a good idea for us to come up with something else like, oh, drainage? I mean, there's a million inspections one could do, or are we kind of crossing into like bringing in?
Yeah, that's a very good question. First of all, I wouldn't be concerned as a realtor that you have liability if you don't do. In other words, you have no obligation to come up with, oh, my realtor wasn't very good because she didn't suggest blah, blah, blah.
Okay.
Don't worry about that. Just once in a while, I think there's a real particular issue on a particular transaction that's unusual. You've come across an unusual issue and you want to highlight it. I think in this scenario, you really need to check out that weird looking tree over there or something. I can't even come up with a good example in my mind. So in other words, I don't think it's an automatic thing that you need to fill out. I think you rarely do it. The contract's very clear and the buyer inspection advisory very clear, making it very clear to the buyer they can do any inspection that they want. And you, the realtor, are not a home inspector. You don't look at the house with the eyes of a home inspector. So you're not the one who would really be the one to recommend various inspections. It's just if you come across, I wish I could come up in my mind an example even, if you come across just, there's something really weird or special about this particular property. Yeah. And it needs something unusual that's not a normal inspection, you might want to recommend it. That's what that's for. Okay. By the way, and Logan's referring to another form that is not required form, but a lot of you probably use called the buyer inspection waiver, which is just a good risk management tool. In other words, it's pretty clear that if the buyer removes their contingencies, they're sort of foregoing their right to complain about things. And it's also very clear the buyer gets a buyer inspection advisory advising them to get inspections. But if you want to just get another level of protection, which is probably not necessary, you want the buyer to actually officially say, I acknowledge that I'm actually waiving the right to do these inspections. They don't have to. If you don't do that form, you're okay. But it's just sort of one more level of protection against the buyer who comes back and says, why didn't you recommend that I do this or this or this? Well, I did give you the buyer inspection advisory, but it makes it even better if you gave them the buyer inspection waiver and they actually specifically acknowledged that they were not doing inspections. Have I ever seen that to be the deciding form in a court case? No, but I think it probably persuades some buyers to just go away and quit complaining. And so, yeah, it's a good form. But obviously, if we thought it was a necessary form, we would have pre-attached it to the purchase contract like we pre-attached the buyer inspection advisory. So I just wanted to throw that in there.
Awesome. Thank you. Appreciate it.
You're welcome.
I have a couple of questions that came in to me sort of anonymously. I'm going to ask folks, if you have a question, to put it in the chat. You can also raise your hand. You go to the reactions part, like there's a tab on there's a bar on the bottom of your screen. You might have to hover over it. But if you have a question, raise your hand. This one kind of got lost in the discussion. Is it legal to have a deposit for a rent back if you're not charging any rent?
Yeah, no, I think I did throw that in real quick.
Oh, okay.
And the answer is yes.
For that.
Yes, the answer is yes. Just because you're not charging a rent for the rent back, it's perfectly okay to require some type of security deposit. Yeah, that's totally okay.
Okay.
By the way, Romeo, real quick to follow up, George Crow made a good suggestion. We have still another good form, the buyer inspection election form. the BIE, one more risk management tool to protect you from the buyer. And this is the one where the buyer, you're very specific on the form, they can actually specifically say, well, why didn't you order the special roof inspection that we talked about? Because you signed the BIE form, the buyer inspection election form, specifically rejecting a roof inspection. That's why. It's almost the level of your paranoia and distrust about the buyer is what's gonna, and you should probably be worried about all buyers, right? So, we got forms, different levels of protecting you from the buyer who comes back and says, why didn't you order this inspection? Because sometimes the buyer will claim, well, it's not a question of whether this inspection is a good idea or not. I specifically asked you to order this inspection. That's what I'm accusing you of. I specifically said you need to arrange for this one and you didn't do it. That's where they would have the burden of proof to prove that. But the BIE form, where they have checked the box already saying they didn't want a particular type of inspection, will obviously kill their argument right there. Let me get Dennis Leibel's question. In this highly competitive market, what can a buyer and seller's agent do when the selling listing agent sends a counteroffer requiring the use of a specific title escrow company and escrow officer? It seems to be a violation of the buyer's rights. I don't know if I would put it that way. I know it's sort of the buyer's purchase and maybe they have a greater interest in choosing a particular title company. And of course, I hope you're all remembering that there is a federal law that says if the buyer is paying any portion of the title policy, they have an absolute right to choose the title company. And I know typically in Marin, you have the title company also doing the escrow. So, but that doesn't mean a seller couldn't counter and say, no, I want this title company with this escrow officer. And as long as the seller is making it very clear that they are definitely going to pay for the portion of the title company's charge that constitutes the payment for the owner's title policy, they can do that. If they're going to ask the buyer to pay any portion of the owner's title policy, it's not non-negotiable. The buyer does choose title. But if seller says, well, tell you what, I'll pay for the title policy, but I want you to use this title company and this escrow officer, they can make that, they can counter that. And then the buyer can decide if they want to do that or not. So that's a very good question. Okay. Blaine Morris has a question. Unfortunately, Blaine, it is a thing. Realtors getting sued for ADA non-compliance on their personal websites. For some reason, this seems to be happening more at Compass than others. I guess there's one guy doing all this lawsuits. There's one guy. There's one attorney who's going around to agent websites and seeing if they meet the criteria so that they will be accessible to web reading, the software where a visually impaired person can read what's on the website. There's this one plaintiff and one attorney who's going from agent to agent and agent websites, and he's claiming that some of them don't provide the access. So and he's filing these. It's like, and he'll go away for a few $1,000s. It's not like he's not even asking for proof that you actually fixed the website. It's like extortion. He wants to get paid for dropping this suit. Anyway, we do have a guide on this, a Q&A on this. I can make it available to Romeo. We have on our website something called quick guides. We have long Q&As, and then we have 1-page or 2-page quick guides, legal quick guides. And we have one on ADA, compliance with the ADA website rules. And you can find it. I can send it to anyone who asks me. I can make sure Romeo has it. You should look at it. It gives you recommendations as how to, what steps to take with your website provider to make sure you're not vulnerable to an accusation that your website violates the Americans with Disabilities Act. So you might want to look into that. It's worth doing. I know the person you have at Compass is pretty good at this, so she'll probably have that information for you. Unfortunately, we can't deal with it on the state level as far as legislation along the lines of, you know, if a realtor does this, they're okay, because we're talking, these are federal lawsuits. It's based on the federal Americans with Disabilities Act. So the NAR, it's an NAR issue. And they're doing, I think they're trying to do something. But the point is, we have resources to help you, steps you can take to make sure, and we're going to come out with more detailed, probably within a week or so. We're going to make it available to all realtors, more detailed, a quick guide, a more detailed quick guide, just telling you about specific steps you can take on your website to make sure you're not vulnerable to any accusation of a violation. So unfortunately, yes, Blaine, it is a thing. Constance, if you're a family member helping a very ill relative with the process of selling, but you're not acting as a listing agent, just an advisor, am I liable and do I need to complete an agency document? Well, if you have a real estate license, right, and you're helping someone, does that lead to an implication that you're acting in a licensed capacity? As long as you're not getting paid, no. I mean, that's the thing that triggers it, right? And even if you are getting paid, you can draft things that make it clear that, yes, I acknowledge this person is not acting as my agent in this transaction. We have a form for that, seller non-agency. So I would recommend either that you don't get paid at all, in which case there's no liability for not getting paid. And otherwise, make sure you use our form, the seller non-agency, and you're otherwise, yeah, then you would need to do an agency form. The idea of using an agency form stating that the seller is representing themselves, no. In other words, if you're providing an agency form, you're admitting that you are acting as their agent. If you're not acting as their agent, don't give them, if you're not getting paid, you don't need to give them anything. You're just not getting paid in this deal, so you can't be accused of, you're not incurring the liability as acting as in an agent capacity in this transaction. Okay. Someone's asking me, my friend Romeo is asking me, remember we got a legal hotline. First, I'm going to put in the chat, by the way, my own information. You can always email me. I respond to all emails. Sometimes takes me a few days, but I do respond. And for quicker service, we have a legal hotline, 213-739-8282, which that number hasn't changed in 43 years, believe it or not. So feel free to call that. Romeo has already put the document I was referring to in the chat about the ADA. Britt, thank you also as a good ADA compliance checker. And also another question I was asked to address is, do landlords have to accept Section 8 tenants? Up until a couple of years ago, the landlord could simply say, nope, I'm not part of the Section 8 program, sorry. It's not that simple anymore. In other words, let's say you get 2 applicants and one applicant is clearly more qualified as far as credit score and income and whatever, but they're a Section 8 tenant. And then you have another tenant applicant who's not as qualified under other objective criteria, but is not Section 8. So you take the less objectively qualified non-Section 8 applicant over the more objectively qualified Section 8 applicant. That person can sue you because clearly you turned them down only because you didn't want to go to the trouble of joining the Section 8 program. So yes, in that case, it's sort of like saying you did have to rent to the Section 8. You had to actually, if you were going to be a landlord and make this property available, you can't turn down an applicant who would objectively be qualified simply because of their Section 8, which means, yeah, you have to join the Section 8 program and be a Section 8 landlord. So if you're in that sort of situation, that's the way it would be looked at. That can't be just it used to be, I don't care about anything else. I don't want to be a Section 8 landlord. And that was sufficient. But that's not sufficient anymore. Okay. All right. Do you have any more, Romeo? I don't see any more.
No, I think, let's see, I think a lot of them were sort of comments. Did you get this one from Constance?
I think so. About the family member helping the ill relative. Yeah, that was addressing that. There's a lot of talk nowadays, by the way, about buyer broker contracts. And I know not many people use them, but there could be some new rules coming. I hate to talk about things that haven't happened yet, but there could even be rules coming that one day you're going to have some type of buyer broker, not necessarily a binding one, but some type of buyer broker contract if you wanted to be successful in a procuring cause dispute. That might happen. I mean, there's so many things in play right now. And people always ask me for updates, like is clear cooperation going to change? Is coming soon rules going to change? And chances are yes. And then of course, complicated by you guys have your own MLS. It's not a realtor owned MLS that is required to follow rules established by NAR, but a lot of times you do anyway. Even though I didn't get any questions to anticipate anything, I have no updates on any of this stuff. A lot of just stuff is being talked about nationwide. You know, even changing the whole commission structure. You may have read about these things. And just in case you were wondering if I was going to raise any of that, there's nothing to update you on, nothing. These things take a long time. So I have nothing to say on that, even though you didn't ask. How's that? We're just getting, we're starting to see another thing relating to all these non-contingent offers is buyers, of course, non-contingent offers, buying the house sight unseen practically, and now they find problem, they're complaining. Realtor, why did you let me make a non-contingent offer? Well, fortunately, it says right in the purchase contract that if you're making an offer without satisfying yourself as to the condition of the property that you're buying, you're acting against the advice of the realtor. And we also have this, remember I was mentioning the sample legal letters? We have a sample legal letter acting against the advice of broker that you can use just to reinforce the fact that it's a risky thing to do to make a non-contingent offer if you haven't really figured out everything about the property. I don't think realtors are generally going to lose these cases, but we're starting to see them as would be predicted. Buyers who make non-contingent offers now, of course, they have buyer's remorse after they bought the house. But you knew that was going to happen. So it's just the way it is. Okay. Constance, the name of the seller non-agency form is actually seller non-agency, believe it or not, SNA, seller non-agency. So, have you ever done a deal where you're the buyer's agent and the listing agent was clueless? Or vice versa, you're the listing agent and the buyer's agent was clueless? And to make the deal work on behalf of your client, you found yourself giving advice to the other client because that was the only way the deal was going to work. That's when you use that form. that's when you say, you know, I'm the buyer's agent in this deal. Seller, I've been helping you, but I am not your agent. Or I'm the listing agent. Buyer, we have a form called the buyer non-agency, the BNA. So I always say, if you find yourself advising the other side just to help your client, but you don't want them to come back and say, well, since she was giving me all this advice, I assumed she was my agent. I assumed that she had a fiduciary duty towards me. That's why you gave them either the seller non-agency or the buyer non-agency forms, so they can't make that argument. Constance's issue was a little bit different, where she was helping, the idea of helping a relative. I'm assuming in that scenario that the person isn't getting paid, because if you don't get paid, is it possible to be an agent without getting paid? Yes, it is. Which is why even in that scenario, if I didn't make it clear, Constance, I would still recommend some type of non-agency, but it's a lot harder for that argument to be successful. Yes, I'm suing this person for not giving me proper advice, even though I wasn't paying her at all. She wasn't getting paid at all. I'm not saying it's impossible that they could win that argument, which is why I probably didn't make it clear enough earlier when I was addressing that question. Yeah, you should get them to sign some type of non-agency form, which would 100% protect you. I'm bringing up things I shouldn't even bring up, but in case you're wondering about buyer love letters, you know, Oregon banned them, but now a federal court recently overturned Oregon's ban of buyer letters. At CAR, we still have the official position that there's something, you know, not that they're illegal, but you really need to think carefully about writing letters on behalf of the buyer, because it makes the seller very vulnerable to a fair housing claim. Because if they get a letter that discloses personal information about the buyer, and then they don't accept that offer, the argument from the buyer is, well, I guess you don't like the fact that I have children, or you don't like the fact that I don't have children, or you don't like the fact that I'm this or this or this. In other words, if you disclose personal information to the seller, if the seller knowingly accepts that personal information, the seller is setting themselves up for an accusation that they discriminated against that person based on that personal information. So that's the reasoning why CAR's official position is that there's something you should really think carefully about before you decide to do. Constance, yeah.
Gov, thank you for answering that question that
Yeah.
I had for you that I hadn't gotten around to asking. That has been on several of our minds, so thank you for addressing that.
Yeah, Constance, again, yeah, I was wondering about the buyer could hold me liable since I'm in communication with them. Yeah. To be 100% safe, get them to sign the buyer non-agency form, the BNA, to be safe. It's very, very unlikely you'd have a problem since you're not getting paid, but to be 100% safe, get them to sign the buyer BNA form. All right.
Gov,
Yes.
you have been such a wealth of information. This is like amazing. Thank you.
My pleasure.
Yeah. There's a lot going on right now, so it's
There is.
a lot of things, but
And I hope to see you and Romeo and others maybe live in Sacramento.
yeah, actually maybe so, which would be cool. So there we go.
Well, probably May or June, I'm going to start traveling myself, so we'll see.
Awesome.
You never know.
Awesome. New era.
Okay, guys.
All right. Thank you, Gov. Good to see you.
Great to see you. Thanks,
We'll
everybody.
see you again soon. All right.
Okay.
Bye.
Thank you all. Thank
Bye,
you for
everyone.
everybody that stuck around.
Yeah. Thanks for hanging out. All right. Bye.